All right, I think with that, we're going to go ahead and get started. Thanks for starting the recording. So I'm going to call this work session on AO 2020-55, rental tax on rental of motor vehicles to order. Let's start with a roll call.
Mr. Rivera.
Present.
Ms. Quinn Davidson.
Here.
Ms. Allard.
Here.
Mr. Constant.
Here.
Mr. Dunbar.
Here.
Ms. Kennedy.
Here.
Ms. LaFrance. Mr. Perez-Verdia. Mr. Peterson. Mr. Weddleton. Ms. Zalatel.
Here.
Okay, you have quorum.
All right, thank you. So as usual, if you want to get in the queue, please put yourself in the chat or text me if you can't access the chat. With that, I'm going to turn it over to Slifka or Mr. Moore to get us started.
It will be Mr. Moore who is leading the charge.
Great.
Okay, so Mr. Chair, I think the presentation was available through the clerk's website. Do I need to try to share, or does everyone have it already?
If you could share it, that would be great.
Okay, I will attempt to share. I'm not great at this, but I will attempt. Hang on. All right, let's see.
Great. We can see it.
You can? Okay, good. Thank you. All right, so we're going to go ahead and just 1 second here. It's asking me to verify something. Okay. All right. I'm going to assume that's working. Okay. So thank you for the opportunity for today's work session. The subject is AO 2020-55. It's a rental vehicle tax amendment to an existing part of the code. It's AMC 1245. If you turn to, and then let me get here to the next page. This is on slide 2. This is a summary timeline. And we just want to remind the Assembly kind of where we've started and where we are currently and where we may go in the future. So June 2nd was the date that this particular ordinance was introduced. It was AO 2020-55. The public hearing was set, and it did occur on June 23rd. And the Assembly opened and closed the public hearing. I believe the only entity or person to testify was Turo, and they requested at the time a delay in action by the Assembly, and that was about a 5-week delay. So this particular ordinance is on the Assembly's agenda for next Tuesday night for approval. And if it is approved next Tuesday night, then the effective date would need to be pushed out from what was originally proposed because of the delay in the action. So we'll talk about that in a moment, but we're looking to have it start October 1st. There's also another issue that popped up a number of weeks ago that we weren't aware of when the original ordinance was passed. We're going to talk about that in a moment. But that deals with a dollar cap issue. If the Assembly wanted to fix that issue, we've been told by the Law Department that it needs to be done at a future municipal election. So the dates on there would be early introduction of a ballot ordinance, early January ballot ordinance, and then next April would be the first opportunity to adjust or to change the wording that governs the dollar cap issue. Just in terms of the core ordinance, the one we originally proposed, if it goes into effect October 1st, that means that any hosting platform businesses such as Turo, there's a variety of them, but Turo is one of the bigger ones, would be required to file their very first quarterly tax return. It would be due on January 30th of 2021. Okay, so we'll go on to slide number 3. And for this slide, I just wanted to preface just to kind of hopefully help the Assembly and any others online understand Turo in just really simple terms. If you want to think of it, Turo is the Airbnb for cars. That's a common way of describing Turo. And Turo is just one company that falls into that. So we make reference to them, but really there's a variety of other companies such as RV Share, Outdoorsy, other ones that actually operate within the boundaries of the municipality of Anchorage. So we want to make sure people kind of understood the correlation between, what we do on the room tax side versus what we're now trying to do on the rental car side. Second overall point is these hosting platforms, whether they're on the room tax side or the rental vehicle side, they directly compete with the entities doing the same type of business. And in this case, it's the business of renting vehicles to customers. So we realize now, we have realized for actually quite some time, that there is this gap in terms of what our code requires and what is actually happening in terms of anyone that's involved in renting vehicles for money. They are all required to pay the 8% tax. And companies such as Turo have not done that at all previously. So that's what this ordinance is all about. We do see this ordinance as very straightforward and streamlined process for the hosting platform businesses to follow. And what we're asking for, requiring is quite simple. They would need to do an initial upfront registration process, complete any of those requirements. That's typically just a one-time requirement that they have to do. The second thing is, once they are registered with us, then they are authorized to collect and remit the 8% special sales tax on rental vehicles. These are rental vehicles occurring within the boundaries of the municipality of Anchorage, and they would report and collect on that on a quarterly basis, so just 4 times a year. So it's not onerous, it's not complex, very straightforward, very streamlined, okay? The actual ordinance, and this gets into the 3 bullets on this slide, what we do is we define the concept of hosting platform. Same thing we did with the room tax area, and that's in its own specially added definition. Once we define that in the code, the second bullet specifies the requirements that apply to the concept of hosting platform. Those requirements generally are register, collect, and remit the tax, very similar to what we do for room tax. On the room tax side, you may recall the history was Airbnb voluntarily agreed to start doing this remitting and collecting a number of years ago, about 3.5 years ago. Then the U.S. Supreme Court came about with the Wayfair decision, which is a monumental decision. And from that point forward, we realized with Airbnb, there was no longer a need for a voluntary agreement. So we wrote them and we said, look, we're going to go ahead and change the code. We're going to make a requirement, and everything will be the same for all types of similar businesses. So Airbnb officially registered in our code, and everything is standard in that regard as a hosting platform. Very soon after that, an ordinance on room tax was passed. VRBO, which is the next biggest competitor to Airbnb, came forward and said, we recognize your new ordinance and we're going to go ahead and come into compliance. They started November 1st of 2019. So this rental vehicles is the last major area where the city is impacted by lost tax revenues because there's activity going on out there that is not being captured. So we define hosting platform, we list the requirements. They're very specific to hosting platform. They're very contained. They're very concise. And then all other definitions and requirements in the code remain the same. So that's all for that slide. If I go on to the next slide here.
Actually, Mr. Moore, apologies. Sure. Just want to note for the record, we've been joined by Ms. LaFrance. Okay. Please continue.
Okay, thank you. All right, and I am going to pause here in just a moment, so there will be opportunity for questions or that type of thing. So amendments to AO. Okay, so the ordinance 2020-55 was introduced on June 2nd. We subsequently realized from discussions with the law department there was some issue, a technical issue, with what we wanted to do in taking away the dollar cap that currently exists. And so we're going to have Dean Gates speak to that in just a moment. So in order to clean up the ordinance to make it, what is actually doable at this moment in time, there will need to be an amendment, I presume, on the floor of the Assembly next Tuesday night, which will remove Section 2 in its entirety, and that will make it, that's a very easy, straightforward amendment to make. The other part of the ordinance that we would recommend making is an amendment to Section 4, which talks about the effective date. And I think originally it was going to be September 1, and what we're proposing now would be October 1, which is 30 days later, in line with the delay by the Assembly that it was agreed to. And also it happens to be the start of a calendar quarter, which also makes it nice and clean. But at this moment, I'd like to pause and ask Dean Gates to just take a few minutes, because I know we started a little bit late, but maybe take 3 or 4 minutes just to update the Assembly on the dollar cap issue. And then as soon as he's done, I'll just come back in and finish off Treasury's presentation.
Thanks. And before you go, Mr. Gates, just want to note for the record that we've been joined by Miss Allard. Go ahead, Mr. Gates.
Okay, great. So thank you, Mr. Moore and Mr. Chair. So I've got a PowerPoint presentation. Can I share my screen? And I'll try to make this very quick.
Sure. How do I think I hit the X here? Maybe does that work?
So let's see. Is my
Yes, we can see your presentation.
PowerPoint screen visible to everybody? I can never be quite sure. Okay. So very quickly, as Mr. Moore mentioned, we talked about the maximum tax that can be collected. So I targeted the caps off not so fast. So we realized after some discussion after some question from Mr. Weatherton, and we researched that this part of this ordinance 2020-55, and I've underlined the title part, and I've also put a quote from the AM, what it intended to do: eliminate maximum tax cap of $120 on passenger cars, $240 on vans, trucks, and recreational vehicles within the first 30-day rental period. That's what it intends to do. It sounds like a great idea. Why not? We would collect a little more tax. I don't see any reason to oppose that, but the law is the law. So that's what I'm going to talk about next. And here's section 2 that Mr. Moore just mentioned. We could probably end up reading all this by amendment on Tuesday night. And at the bottom are the history notes, and that led us to, I guess, the conclusion that Mr. Moore summarized for you. So 245 as amended, it is referenced in a ballot proposition. So it put this proposition on ballot in April 4th, 2000. Now, according to charter, of course, as we all know, or for most of us, to implement a sales tax, to levy a sales tax that requires voter approval by 3/5. And this proposition passed the voters. The wording of it's important, though. I highlighted that part. The operative language was on the Proposition 3 was, shall Anchorage Ordinance 2045 AM be ratified? And so what does that ordinance say? Because that's what the voters are approving. So 2045 as amended, it's about a page and a half long. And this is the section, and you recognize this language because that's the language that's being amended in section 2 of AO 2020-55, right? And I highlighted that provided that language. So this is part of what the voters did. They approved, excuse me, let me go back. They approved the levy of 8%, but they also required that there was a maximum amount, not to exceed these dollar amounts. You know, if you do some math for an average rental these days, $75 come out to about a $75 per day rental might come to about $120 in tax after 15, 20 days. So this actually has us losing some revenue for the full 30-day period. So again, it sounds like a great idea. But can this be removed by ordinance like we plan to do with the 2020-55? And with a little legal research, I came to the conclusion, no, because of Alliance of Concerned Taxpayer versus the Kenai Peninsula Bureau. And just to summarize, the voters authorized the Kenai Peninsula Bureau to have a sales tax of up to 3%. Years later, in 75, the road decided to lower it to 2%. They didn't need that much revenue, I guess, for its purposes. And then years later, I think it was 2006, Ordinance 9 is going to increase it from 2 to 10% back to 3%. They needed more revenue again. But of course, we had a lawsuit against the Bureau here, and the court held that the Bureau had a right to impose on 3%. But I actually really liked this quote. They quote relied on a California case, and the last line really hits home the point. The evil to be counteracted is the increase of local taxes beyond what was formally approved by the voters. So the borough could go down to 2, back up to 3. They can never go over 3 without more voter approval. So can we do this with our tax? And the answer is no. We shall not exceed the amount that was approved by the voters, the maximum amount. We couldn't exceed 120 unless we got voter approval to go beyond that amount. So we don't want to do what's evil. That's gone because we're going to delete section 2. And so talking to Mr. Waterson, thought this would be more understandable if we displayed the ballot prop and some of the language and some of the case law ruling for you. So if there's any questions, I'll take them now, or we could go back to Mr. Moore.
Sure, I have a question for you, Mr. Gates. Mr. Dunbar?
Yeah, Mr. Gates, I put it in the chat if you want to read it there, if you can see the chat. But basically, you're saying that this is all under the tax?
Okay.
That? And so if we're capping that, then isn't the effect actually slightly increasing property taxes?
These funds, and Mr. Moore, I think, can corroborate what I say, that these are new property taxes. So if we remove the cap, we'd be collecting some more motor vehicle rental tax. That would be a little less in property tax. Right. And I don't remember the dollar amount that we would collect more of if this is removed. Anyway, the solution is to put this on the ballot and have the voters remove this cap. And one of the points in our discussion about this was that for things like a motor vehicle rental tax or bed tax, voters are pretty much in favor because it's mostly tourists that pay them and not residents that live here. So,
thank you, Mr. Gates. I think I was mostly...
And you're correct, Mr. Dunbar. The cap doesn't not increase, but it doesn't provide as much property tax relief as we could without the cap.
Right. Thank you, Mr. Gates.
Thank you. I don't see any other questions for you, Mr. Gates. Thank you so much. I'll turn it back to Mr. Moore.
Okay, thank you, Mr. Chair.
Okay.
Can you all see that again?
Yes, we can.
Okay, good. All right, let me scroll down here. Okay, so we're going to go, and this actually talks about the point real fast. So Assemblymember Dunbar just asked about. So we had a summary of economic effects for this ordinance. The original ordinance included removing the dollar cap, and there's a footnote here at the bottom in bold on this page, which says removal of the dollar cap provision is estimated to raise nearly $500,000 in additional taxes. That is raising additional taxes, but as we see on the very next slide in the revised SEE, we have a footnote pointing out that rental vehicle tax has always been and will continue to be within the tax cap. So without this dollar cap provision removed, the city forgoes the opportunity to provide additional property tax relief. And so what we're left with on this slide, this is slide number 6, is a revised summary of economic effects that only focuses on the projected fiscal impact of the hosting platform businesses being subject to the tax. And in this case, you see the number in fiscal year 20 is quite small. The fiscal year 21 is fairly small, and then it jumps up a bit more in the out years. I will say that for the fiscal year 20 and 21, it does account for the projected effects of COVID-19, which makes these revenues very, very understated as they would normally be. So that is what's reflected there. I also will just comment that these particular revenues that focus just on the hosting platform businesses are conservative in nature. When we proposed the hotel, the similar provision for room tax, and we were thinking about Airbnb and other businesses. I think at the time we thought it might bring in $200,000 of additional money. It turned out to be several times greater than that. But one of the challenges we have is we have no idea how big the market is, and businesses like Airbnb or Turo, any of these types of businesses, they don't share that type of information with us. So it's kind of our best guess to estimate the revenue impact, but in this case, we tried to be quite conservative. I would not expect rental vehicle to produce the same impact of many hundreds of thousands of dollars that room tax did, but it still could be more than what you're seeing on this particular page. Okay, so that is kind of this summary of the fiscal impact. And if I go on to the next slide here, this is on slide number 7. This is just some additional comments and perspective. And one thing worth noting, if anyone's done any internet research on this subject, there's a lot of terms that are out there that can get confusing, and there's just a lot to digest. But what we found is one of the jurisdictions that actually currently works with Turo and they collect the sales tax on rental vehicles is Connecticut. And so we went to their website and we saw 2 quotes, and those are the first 2 bullets that came from the Connecticut jurisdiction. And in this case, I'm just going to read the first quote. The other 2 I'm going to just paraphrase, but the first quote, I think it helps understand what we're talking about. They say PTP, which is peer-to-peer car sharing, and that's a company like Turo. This refers to the sharing of privately owned vehicles in which companies such as Turo broker transactions among car owners and renters by providing the organizational resources needed to make the exchange possible. They provide an online platform, customer support, safety concerns, and auto insurance. So that is kind of a foundational piece of information there. The second quote also comes from the Connecticut jurisdiction, and they're actually quoting a Forbes magazine article. And in that article, they spoke with the American Car Rental Association, which has a very large voice on this issue and a lot of other issues related to the rental cars. And in this, and I'm just going to paraphrase this because I don't need to read the whole quote, but basically what the Car Rental Association said is PTP car sharing companies, such as Turo, they rent cars, they profit from renting cars, and they rent cars to consumers. Those are very key elements that tie into, yes, they do need to comply with all law here at the municipality that deals with taxation of rental vehicles. The final sentence in this second bullet is quite important. It says, and this is a quote from the American Car Rental Association, the argument that these companies are simply facilitators didn't work for Airbnb and Uber, and it won't work for the peer-to-peer car rental companies. So that's that quote. The last bullet on this section, on this slide, is just sort of a composite comment from Treasury. This is 2 or 3 people involved in Treasury that put this together. But a lot of times there's the word sharing, and sharing sort of implies no money is involved. It also sometimes people say, well, hotels are different than vehicles and things like that. So what we're saying here is sharing, whether it's real or personal property. In both cases, we're talking about tangible property that's being rented, and that means that they are subject to our municipal code. And there are these market facilitators, we call them hosting platforms, that make these transactions possible. And so neither Airbnb nor a Turo or any other type of company that share property, whether it's a hotel or a house, extra room in a house or a vehicle, any of those sharing operations, there is money exchanged for the temporary use of that property by a guest. And that this constitutes renting of property, regardless of whether it's real or personal. And so we just wanted to get that out there, that the crux of the transaction that we're talking about is the rental of property for money, and whoever is involved with handling that money and facilitating it, the transaction, the broker of the transaction, they are subject to collecting and remitting that tax to the municipality of Anchorage. All right, I'll go on to this is our last slide. Then there's an appendix that's just there for additional information. But what I wanted to just highlight here is we have reached out to Turo in the past, and we sent them a formal letter in 2017. That was in August of 2017. We even sent a letter to a company called Relay Rides, which was a company that Turo acquired. And we sent that letter to Relay Rides in 2013. So we've been trying for many years to get the attention of companies like Turo so that they will come into compliance with our existing code. And that, of course, hasn't happened. On June 2nd, when we introduced the ordinance, we sent another letter to Turo advising them there was this ordinance, and we invited their comments, and we asked them to please be prepared to come into compliance in the near future. Since that introduction of the ordinance, there was, of course, the public hearing on the 23rd of June, and at that time, Turo, I provided some verbal, I think by phone, it was verbally provided some of their issues or concerns. And so what we did in Treasury is 2 days later, we sent an email to Turo, to the same person that testified during the public hearing. And we asked that person, her name was Kendall, we asked if she could please respond to 2 basic questions. And that is on the very back, second to last page of the appendix. But those 2 questions are, and I'm just going to say these very quickly, I'm not going to read the whole thing, but basically the first question was, please provide a comprehensive list that would name all government jurisdictions in the US or Canada where Turo is currently collecting a rental vehicle sales tax. So that was the first question. The second question was, please explain why Turo has not voluntarily complied with Anchorage Municipal Code 12.45, which covers rental or booking of vehicles. And so those are the 2 main questions. We sent that out on June 25th. It took 4.5 weeks before we ever got a response to those 2 questions. And that was on July 20th, which was the beginning of this week. I am very much appreciative of Turo's initial response because it did give us information that we did not have before, and they listed quite a number of jurisdictions all around the U.S. where they are already collecting a sales type tax on the rental of vehicles. So there is precedence here. There is a platform that they already have built that is able to accommodate the various jurisdictions around the country and what is taxed when it comes to renting of the vehicle. So that was good news to us. So we know that they can do it. They're doing it right now, and there's a platform for them to do it. So that was the biggest takeaway from that initial response. The only other things I'll mention here, and then we'll be completely done at this point, is we did a fair amount of research trying to find out more about Turo as a company in terms of how they've addressed this subject in the past, because they're a pretty big voice when it comes to peer-to-peer car sharing type issues. And so in our research, there's just 2 things that really popped out to us that we wanted to make sure to share with the Assembly. One is that as recently as 2 years ago, Turo's website homepage had the tagline, "Rent better cars." That was their main headline on their homepage. So they acknowledged through those words they do rent cars, and they are a direct competitor to any other person or entity that rents vehicles on a short-term basis here in the municipality of Anchorage. The unfairness of this is that they're able to rent at prices that do not include the 8% tax, and that gives them a competitive advantage over other businesses that are doing the same type of transaction. And so that is something that we hope to correct with the ordinance. The second point, and this is the final point, and I'll be done, is in our research, we found that there was a lawsuit filed by the state of Alaska. State of Alaska, and this is against Turo, state of Alaska has a rental vehicle tax of its own. It's very similar to ours. They have no dollar cap. And just to backtrack on the dollar cap issue, we researched all of Alaska and a whole bunch of areas all throughout the United States. We found no other jurisdiction that has a dollar cap in place like we do. So it's highly unusual for us to have that. And our recommendation is, if it takes going to the voters to remove that, we would recommend removing that. It just doesn't make sense to us that we have it to begin with. So anyway, but back to the Juneau lawsuit, or the state of Alaska lawsuit that was filed in Juneau. The judge in Juneau heard the case. It was try to get information from Turo about how much business is occurring in the state of Alaska, and to just basically be able to work out what they need to do to be in compliance with collecting the tax. What was said by Turo in that lawsuit was that Turo took the position that neither Turo as a company nor the private owner of the vehicle had any responsibility whatsoever to collect the tax on a rental transaction of a car. So they're saying they don't acknowledge in any way on any side of anything that they involve with themselves or the person that's using their service, that anyone is responsible for paying this tax. And that was very surprising for us to read that. And so anyway, in conclusion, we have had great success with Airbnb, VRBO, very, very large companies on the room tax side. We see them as very responsible corporate partners and ones that want to be in compliance. We also know the Wayfair decision says that this internet activity that occurs no longer has to require physical presence. And so therefore, it is fair game for the assembly to approve an ordinance that says you are required from this point forward to collect and remit the tax, just like you would if you were physically located here. So with that, that's the end of our presentation. Thank you, Mr. Chair.
Thank you, Mr. Moore. So I'm going to go ahead and turn it over to Assembly discussion. Also want to note for Assembly members, I believe we do have some industry representatives with us today if you have questions for them. So at this time, I'll open it up to discussion from the members. I know it's been a long week. Ms. Zoll.
Go ahead.
Thanks for the presentation. And since we do have industry representation, I was wondering if we could give them 2 or 3 minutes just to provide us a little bit of feedback about this ordinance, just so we can hear both sides, please.
Absolutely. So I think industry folks are on the phones and most of you are muted. So to unmute yourself, it is *6. And I'm happy to hear from a few of you if you would like to speak.
Hi, this is Sean Vink from Turo. I'm available to offer a few comments if that's appropriate now.
Go ahead, sir.
Thank you. Again, my name is Sean Vink. I'm a senior counsel at Turo. There's a great deal to respond to in the presentation that we just heard. I'm going to try to respect your time and address my comments to a couple of key points. We oppose the ordinance as written. We think it's unconstitutional. We think it's technically flawed, and we think it will actually run contrary to the stated purposes that the policymakers have articulated today. Constitutional problems, Wayfair decision was referenced. Wayfair decision allows state governments to extend collection and remittance requirements to out-of-state businesses that don't have a physical presence, if and only if there are certain protections against undue burden on interstate commerce afforded by the jurisdiction. The problem with this ordinance is that none of the protections that the court found in Wayfair were mandatory. Protections such as an economic nexus standard, an empirical threshold for defining the volume of activity that would trigger collection and remittance obligation, protections against retroactive tax collection obligations after the Wayfair decision, things such as participation in the streamlined sales and use tax agreement, a national interstate compact that tries to align and standardize sales tax compliance, the provision of tools by the jurisdiction to enable retailers to collect and remit if they are out-of-state businesses. These were all factors cited by the Supreme Court in Wayfair that made the difference between finding the South Dakota long-arm statute constitutional. This ordinance contains none of the protections that the Supreme Court found decisive in Wayfair. And so on that ground alone, you face serious constitutional questions about its enforceability. And we think that the better approach would be to craft an ordinance that reflects the path that was laid out in Wayfair by the Supreme Court. It's not a self-executing decision as was suggested earlier in the call. The state and local governments have to follow a particular path in order to craft the constitutional statute. This ordinance doesn't do that. Second point is that there are questions, because of the nature of our business at least, about whether the jurisdiction has the authority to do this under the Communications Decency Act, Section 230, which prohibits local governments from holding platforms liable for content generated by their users. It was stated earlier that Turo is a broker of rental services. We would object to that language for the simple reason that we don't own any vehicles. A rental transaction is a transaction that is engaged in by a person that owns a vehicle who makes it available to somebody else for a period of time in exchange for consideration. We do not own any vehicles. We do not have employees in the jurisdiction. We have no physical office in the jurisdiction. The transaction is between an owner and a guest. The platform that we provide allows owners and guests to meet one another to decide upon whether they want to share a vehicle and to decide upon the rate. We do not specify the rates. Neither the guests nor the owners of the vehicles are agents or employees. We are a platform. So the Communications Decency Act and other federal statutes accord certain protections to us, and those need to be addressed as well before an ordinance goes into effect that would be enforceable. The third point that I want to raise, and this I will try to wrap up after this, is the ordinance is written, I think, suffers from a couple of technical flaws. I want to draw your attention to the exemption that is accorded to branded, I believe the term that is used is branded platforms. We think that this is so broadly written that it could provide, and I'm sure unintentionally, an exemption that would allow the traditional brick and mortar rental industry to be exempt from having to collect and remit the tax that is currently collected and remitted on residents by simply using their proprietary website as the mechanism of the transaction. I'm sure that wasn't the intention, but I think it kind of points to some of the issues with the structure and technical details of the ordinance. I also think that there are questions about whether it is over-inclusive, and that also relates to the exemptions that are listed in the statute. So I think that we would suggest that there is a path to craft some kind of a mechanism that would require out-of-state businesses such as ours to assume the responsibilities of collection and remittance and to assist the city and municipality of Anchorage in that way. The Supreme Court has laid out a path to do that. This ordinance ignores that path, and we think a better approach would be to follow it and to address some of these other technical problems. So I will leave it at that. Thank you for the chance to speak.
Thank you. So I do have, I think, a question for you, sir, from Mr. Constant.
Actually, no, I will rescind. I just have a philosophical question about if Uber or Lyft can be taxed, why couldn't these groups? But he changed the response to there are alternative ways, and so I'll allow the attorneys to ponder that. Thank you.
Thank you. Seeing no other questions, I guess I would ask if the administration has any thoughts from what was just said.
This is Dan Moore. I just had a couple thoughts. One is I don't think there's anything preventing a company like Turo from just voluntarily following the ordinance. I think there's opportunity to try to raise different legal theories, but the ordinance is easy to follow. It's straightforward. It was totally acceptable to Airbnb and VRBO. They're very large companies. It's the same type of environment that they operate in. And so I don't, I guess a company like Turo can oppose or fight this, whatever, but they can also choose to just comply. And they have complied in many, many jurisdictions all around the country. So I don't think our language is so onerous or problematic as they say. It has worked on the room tax side. We've had no issues with it. We also asked in our email chain, you'll see it in the appendix, starting on July 2nd, we said, please let us know if you have any specific wording changes to this ordinance. And that was July 2nd, and we heard nothing. So, we've tried very hard to communicate with Turo, to solicit input, and we just haven't received any cooperation. So to me, if it works for Airbnb, it should work for Turo and all other companies that are in that same world. So that's all I'll say. Thank you.
Thank you. Ms. Vogel? I can't hear you, Ms. Vogel.
Yep, nope, sorry, it took me a moment to unmute. Problem with the chat button on my phone. Okay, so first of all, I don't know if Todd is present and interested in speaking. I know he's looked into this a little bit. Treasury also had some preliminary legal analysis done. Obviously, we only got some of Turo's comments yesterday. So far, we are not persuaded by the legal arguments. We don't think that they've read Wayfair correctly at all, and we think that their Communications Decency Act argument is far-fetched at best. So essentially what we have here is car rentals happening in Anchorage, and the money is being collected by Turo, and individual renters have not been paying their individual owners of the cars have not been collecting or remitting car rental tax. So this makes some sense because Turo is the one who handles the financial transactions with the customers. But there's no doubt that there's car rental happening here, and there are taxes that need to be collected. So Turo's option is either have all of the people who are renting cars under their platform subject to, tax fraud prosecutions for not paying those taxes, or to step up as a platform similar to what Airbnb did and pay them for them. They could have and should have done this voluntarily. We're now helping them get there by having this in this ordinance. But frankly, these are taxes that are owed to Anchorage. This is car rental that is happening. As the platform that is hosting and collecting the money and dealing with the transactions, they should be the ones paying the taxes. And I just don't find their legal arguments persuasive. That said, I see Todd is on or is in this meeting, and I would love to hand it over to him if he has additional thoughts.
Sure. Mr. Sherwood?
Yes, Mr. Chair, this is Todd Sherwood, Assistant Municipal Attorney. And the, what was his name? Sean, I think. I saw his arguments in more detail only this morning. So I did look in a different context at the Wayfair decision 2 years ago when it came out, reread it again this morning. And not surprisingly, lawyers disagree because they really only had one holding in that, and they overturned a about 20-year-old decision called Quill, which said you have to have a substantial physical nexus in the state in order to tax them. And they overturned that in the age of the internet and said in so many words that there is enough in the case of South Dakota and what they were doing. So that was the one holding. Now, they did state with just kind of approval, we call it dicta in lawyer talk, some of the things South Dakota had done in their law. And one was saying that if you're a very small internet provider of some service or something, I think it was under $100,000 a year and under 200 customers or 200 transactions or something, then this doesn't apply to you. South Dakota could go to them directly and get the tax from the seller, but the person providing the internet platform wouldn't be responsible. And they also, Mr. Vink talked about this national organization, which was designed to simplify this somewhat for the platforms. And they did sort of make positive comments about that. But one, those aren't holdings of the court. So I don't see that those are mandatory provisions. The other thing is Alaska is very unique in that it's one of 5 states that doesn't have a sales tax, but it's the only one of the 5 where individual communities are allowed to have some form of sales tax, even though there isn't a statewide one. And so it doesn't seem that there's this level of complexity that might have concerned the court that would be somehow interfering with interstate commerce. And here we're asking in this case Turo, but it's really a handful of companies to simply pay a 8% tax, and it's a pass through because the person paying it, of course, is the customer. And that's all that's being asked. None of that seems to rise to the level of complexity that the court in passing was concerned about in that decision. The other thing I'll mention, he mentioned the Communications Decency Act, and I just had a chance to review his comments and the cases he cited. I didn't see any cases that dealt with paying taxes. They have more to do with actual content. And so just for an example, I don't see that Turo would be responsible for somebody saying, my car can drive on water, no problem, and then the car doesn't drive on water. You know, if someone using the platform says that, that seems to be entirely different from being responsible for passing through taxes that they receive under this ordinance. Those are my only comments.
Thank you. Hold on. Okay, so I think we're going to end with a question by Miss Allard. Go ahead, Miss Allard.
Thank you. Can you hear me okay?
Yes, we can.
So I do have sort of a concern with it, and the fact that I was thinking and speaking with someone else, and it sounds like it could be when someone rents out their house for the weekend. I don't believe they're taxed on it. And I'm finding that when individuals, I'm aware of the Turo website, and I've actually used it before. And I'm concerned that when someone's maybe using their vehicle or lending it out for someone to rent it as means to help pay for their vehicle, I don't see taxing it as a good thing, but I don't know. I'm a little split on it. I'm kind of leaning towards I'd like to hear more information from Turo, so if they can reach out to me. I'm Jamie Allard, and I'm concerned about every little thing that anybody does with their vehicle or their homes or anything else, and I think this is just going to set precedent. Thank you.
Thank you. And yeah, I'm going to assume that Turo knows how to find our information. So we only have 1 minute left, but I can go ahead and give that 1 minute to the 3946 number. And if you're muted, it's *6. *3946. Are you with us?
It looks like it's Alex in the chat box.
3946.
No, the person is a representative enterprise. Mr. Mackey, are you able to hit *6 to unmute your phone?
Yes, can you hear me, Mr. Chairman?
Yes, but before you go, sorry, your minute's up, but I can ask for a motion to extend by 5 minutes, but I don't want to use 5 minutes, please. So can I get the motion, please?
So moved by Constant.
Second? Can I get a second, please?
Second.
Second by Dunbar. Any opposition? 3, 2, 1. Seeing none. Go ahead, sir. Gentleman from Enterprise, you may. The floor is yours.
Hello?
Yes, go ahead. We can hear you.
Okay, sorry. My speaker switched over. My name is Jerry Mackey, and I am a lobbyist for Turo for the state of Alaska, but I do not lobby for them at the municipal level, so I'm speaking as a Anchorage resident. I do have some knowledge about this issue. I won't try to recap everything that I did send an email on, but I wanted to point out a couple things. Number one is I have nothing on the legal arguments. It's pretty much standard that Truro will do in most jurisdictions around the country when they're opposing it, and wait till the last minute and then try to tie it up. And that's all I'll say on that. But what I will say is companies like Enterprise that operate out of the airport, out of Anchorage Airport, and collect and remit taxes to the city, they are brick and mortar companies. They have employees. They contribute to, charitable things in the community, all those kind of things, versus companies like Truro, which are outside of the state and by their own admission don't feel that you have the authority to tax them and so forth. That's the same thing they say to the state jurisdiction. As an Alaskan born and raised, that's offensive to me. Enterprise's business model is very simple. All they want is a level playing field under which to do business. They don't want any loopholes that favor them. They don't want to oppose new initiatives or technology or innovative ways to do business. They just want to be treated fairly. And their business model is simple. They will offer you the best customer service they can and at the lowest price. And in order to do that, all things need to be equal. So if I can rent a Toyota Corolla from Truro, or I can rent the same vehicle from Enterprise, that's renting a vehicle. That's not sharing anything. And I think the municipality is missing out on lots of revenue. The state is missing out on lots of revenue. And I just think it's wrong. And I think this is standard operating procedure for them to try to delay all around the country. I'm really happy that the Assembly is looking at this issue. I think the staff's presentation was phenomenal. It was right on the money. I'll leave the legal argument to the lawyers, but I strongly encourage you to enact this ordinance so that those that are doing business in our community and renting vehicles, which is what this is, regardless if they're a sharing platform, as they call it, or a straight up internet platform like Enterprise or Hertz or anyone else, they should all collect the same tax. They should all remit it to the municipality, and it should be a level playing field for them to offer the very best deal to the people out there. For them to have a huge advantage over the brick and mortar companies is just flat out wrong. And it shows their arrogance, in my opinion, that they're not willing to just understand that and compete and pay the taxes like everyone else has to do. So I will keep it real short and simple. I appreciate the extra opportunity, Mr. Chairman, to testify, and I'm available if anybody has a question, but I know you're short on time. Thank you.
Thank you. Yeah, and unfortunately, we are out of time for this work session, but I invite
Jerry,
very briefly, Mr. Constant.
You said in your comments that you represent Truro at the state, but not locally. And I think you might have said something funny there. So could you just clarify?
I said I am a registered lobbyist for Enterprise Rent-A-Car Company at the state of Alaska, and we're pushing two bills in the House and the Senate to do this very thing in Juneau. But I wanted to be in full disclosure to state that. However, I'm not a municipal ordinance. I'm testifying as a citizen.
No problem. I think you misspoke and said Truro, but thank you.
Thank you. So I want to invite both Truro and Enterprise. If you would like to email us any further thoughts, feel free to do that. With that, I'm going to end this work session. Thanks, everyone.